Welcome to Just the Facts. I'm Alex.
And I'm Jordan. Today, we're tackling a complex and really a critical question. We've all seen headlines about the federal government deploying law enforcement or the National Guard in response to unrest.
Right.
But what is the president's actual legal authority to do this? Where does that power come from? And more importantly, where does it end?
We are going to get to the bottom of this by looking at the law itself.
Okay.
We'll cover the unique situation in Washington, D.C., then contrast that with the 50 states, and finally explore what power states have to push back against federal intervention. For our listeners, all sources like the Home Rule Act and relevant court cases will be in our show notes.
Excellent. So, Alex, let's start with Washington, D.C. It often feels like the epicenter of these actions. If the president decides to federalize the D.C. police or call in the Guard there, what gives him the right?
Well, it's crucial to understand that D.C. is not a state. That's the legal starting point. Article 1, Section 8 of the Constitution gives Congress direct and exclusive legislative authority over the Capital District.
Okay.
Think of Congress as the ultimate landlord.
And so, while they've rented out the property, so to speak, by allowing D.C. to have its own local government, they kept a master key.
That's a perfect analogy. And that master key is found in the D.C. Home Rule Act, specifically Section 740, Emergency Control of Police.
Okay.
It says if the president determines an emergency exists, he can order the mayor to provide the city's police force for federal purposes. And the law is clear. The mayor must comply.
Wow, that's a staggering amount of power. Is it a blank check, though? Can the president just decide there's an emergency and take control of a major American city's police force indefinitely?
No, and the limits are written directly into the law. It's not a blank check.
Right.
It's more like a short-term loan with strict repayment terms.
I see.
The initial directive only lasts for 48 hours. So to go beyond that, the president has to formally notify Congress in writing with his reasoning.
I see. Okay.
And even with that notification, the authority automatically terminates after 30 days unless Congress itself passes a new joint resolution to extend it.
So in D.C., there's a direct line of command, but with a very clear congressionally controlled off switch. Okay, now let's step outside the Capitol.
Right.
This is where the lines get blurrier, and the conflict between federal power and states' rights really heats up. What law governs the president sending troops into, say, Oregon, especially if the governor is adamantly opposed?
Right. This is where the conversation shifts to a much older and, frankly, much more powerful law, the Insurrection Act of 1807.
Wow.
This is the main exception to the Posse Comitatus Act, which is a cornerstone of American law that generally prohibits using the military for civilian law enforcement.
The Insurrection Act. It sounds like something right out of a history book. How has it been used?
Its history is, it's the story of America's greatest crises. In a cooperative way, a state can request federal help. But the real power is in its unilateral use. It allows the president to act alone if he determines that unlawful obstructions are preventing the enforcement of federal law, or if a state is unable or unwilling to protect the constitutional rights of its citizens.
And that's the provision President Eisenhower used in the 1950s to enforce school desegregation in the South. He sent the 101st Airborne to Little Rock to protect the rights of black students.
Exactly.
Directly opposing the state's governor.
Correct.
And it highlights the dual nature of the act. It can be a vital tool for protecting civil rights. But the language is so broad, phrases like unlawful obstructions or hinders the execution of the laws, that critics worry it could be abused.
Right.
And here's the key fact. The Supreme Court ruled way back in 1827, in a case called Martin versus Mott, that the decision to invoke the act belongs exclusively to the president. His judgment is final.
That's a heavy burden and an immense power for one person to hold, which leads us to the final crucial question. What can a state do? If a governor believes the president is misusing the Insurrection Act, can they do anything besides just protest on TV? What recourse do they have?
They absolutely have recourse, and it's grounded in the 10th Amendment and the very structure of our federal system.
Okay.
So the key legal concept here is the anti-commandeering doctrine.
That sounds technical. What does it mean in simple terms?
It means the federal government can't force states to be its puppets. The Supreme Court affirmed in cases like Prince versus United States that Washington can't commandeer state resources or personnel to enforce federal law.
Interesting.
So while the president could federalize a state's National Guard, he couldn't force the state police or a local sheriff's office to assist them. Those state and local officials can legally refuse to cooperate.
So a state can enact a policy of non-compliance, but can it legally challenge the president's order itself?
Yes, the main avenue is the court system.
Ah,
A state attorney general can immediately sue the federal government seeking an injunction, that's a court order to halt the deployment. They would argue that the president's actions are an unconstitutional overreach and that the facts on the ground do not meet the legal standard for invoking the Insurrection Act.
so the ultimate showdown isn't a physical one between troops and state police, but a legal one before a federal judge.
Exactly. It shifts the crisis from the streets to the courtroom, where a judge has to weigh the president's extraordinary powers against the constitutional rights of a state.
So here's a question we'd like you to think about. The Insurrection Act was written in a time of muskets and rebellions on horseback.
Right.
In our modern, politically polarized era, is this broad presidential power a necessary safeguard for national unity and civil rights? Or is it a dangerous anachronism that's ripe for abuse?